Without further ado, let me just read the course numbers, because we're going to go ahead and film this today. The first is Major Contributing Cause Standard in the Workers' Compensation Law and its application to claims, course number 93555, offering 103-0460, and the second is Evaluating Workers' Compensation Claims for Settlement, course number 93669, offering 103-0458. So the first subject we're going to talk about is major contributing cause, okay? And we'll work that into settlement evaluations once we get there, okay? First and foremost, your injury, the claimant's injury, has to arise out of and occur in the course and scope of employment, okay, of the claimant's work, okay? Going on to the definition of major contributing cause, okay, prior to 2003, where you have competing causes, okay, we're talking about a prior injury and we're talking about a work-related injury. Prior to 2003, the injury resulting from the subject accident must be greater than any other cause contributing to the disability or need for treatment, okay? So it must be more likely than not related to the subject accident, your accident, the accident that you guys are getting, the accident that's being reported to you, okay? Now, in 2003, what the legislature did was they kind of further defined it, okay? They made it easier on everybody, okay? What they basically said was, what you need is, you need 50+%, okay? 50+% on your injury, okay? So in the outline here, I've indicated 51%, okay? And if you look, the outline's 5 pages, but if you page through and pass your outline, okay, you're basically going to see this, okay? 51% is your major contributing costs, okay, on any and all accidents post 10103, okay? So if you're a provider, whether it be a PCP, an orthopedist, a neurologist, a psychiatrist, etc., indicates to you that the condition that he or she is treating, okay, is 51% or more related to the subject accident, then it's compensable, okay? Then it's compensable. That's your magic number, okay? It's a lot easier than folks make it, okay? 51%. And you can go to any and all of your authorized providers, and they have to give you this opinion. Now, sometimes you're going to run into providers that don't understand that. And that's when you can kind of get into the older language, more likely than not. But certainly we have a nurse case manager here, and you know how that goes. It's got to be more likely than not related to this accident, or treatment is going to be suspended, or treatment is not going to be offered, okay? So 51% is what you're shooting for or not shooting for, okay? But you need to get that one way or the other. Okay, that's your magic number. And below that in 2A, you're going to see may only be established by medical evidence. Okay, so that means where we have to go is to the providers, okay, to secure, to obtain that 51% opinion, okay? And in a couple of minutes, what I'm going to do is we're going to go over a case example, okay, so that I'm just not lecturing here today on the concepts, so we can see how it works. But I want to talk about a couple of things before we get there, okay? Page 2, subsection B, application of major contributing cause, okay? There's 3 cases that I want to talk about real briefly, and I've cited them in here. One is Osceola, the other is Baczynski, and finally Perez, okay? Osceola first, okay? Basically, this case stands for the proposition, okay, that if a claimant has degenerative changes, okay, and I'm sure that you've all seen that on MRIs. As everybody here, most of you have seen it on MRIs, you'll see degenerative changes. You'll see condition chronic in nature, okay? You'll see the phrase indeterminate age, okay? And immediately what we want to do is we want to jump all over that and we want to say, okay, do I have an MCC issue here, okay? The problem is that what Osceola says, despite those findings, you have to show that there was medical treatment, okay? So if you get this MRI that says degenerative changes, that says chronic in nature, that says age indeterminate, okay? But you take a claimant statement and a claimant says, no, I've never treated for my lower back before in my life, okay? What Osceola kind of stands for is, then you can't use it. You cannot argue it, okay? Even if a current doctor argues it based on an MRI, okay, or based on any other kind of diagnostic test, okay, we have to have something previously, okay? Even if a claimant says, oh yeah, 3 or 4 years ago, my back hurt, at least that's a starting point. But just because it says degenerative changes, okay, there's a lot of work to be done to get from point A to point B, okay? I don't necessarily agree with Osceola, okay, but that's basically what the opinion says. We just can't take prior findings with no treatment and use those to argue MCC, okay? The next case is the Basinski case, another interesting case, okay? Basically what this case stands for, the proposition is that we can't use a prior work-related injury to argue MCC, okay? And I'll give you an example of that. Let's say someone hurts their back with the school board 5 years ago and herniates a disc, okay? And that individual treats for the disc, okay? Ultimately goes back to work. And let's say the statute ultimately runs on that case. Let's say for all intents and purposes it's a med-only case, okay? Then subsequently the claimant injures the back again and there's the disc, okay? We can't say, oh, it's a result of that old disc, or get a doctor to say, oh, it's a result of that old disc. Oh, and by the way, the statute's run on that case. No, no. What Basinski stands for is you can't use the old one to deny the new one, okay? Now what we can do is we can go to that doctor and we can say, we can ask him or her, well, would there have been an aggravation of the old disc? That's really what we're looking for. And it kind of takes it out of the realm of MCC, and we can argue an aggravation or an exacerbation, okay? But as far as saying, no, this disc isn't ours, it's for the old accident, no, you can't do that, okay? And finally, the next case before I get into the example is the Perez case. And that basically stands for the proposition that once compensability is established for a specific injury or condition by stipulation, okay, or adjudication by the judge, it's yours, okay? So we have to be very, very careful with that, okay? Stipulating to certain things, okay? And some claimants' attorneys will interpret a stipulation as being a response to a petition, okay? So you have to be very careful as far as what you're accepting and what you're not accepting, okay? Using, in the case of a herniated disc, let's say, okay? You can always indicate the lower back's been accepted as compensable, okay? And that would allow us or you to argue at a later date, we're only talking about the exacerbation, okay? Use lower back, okay? Use a generalized body part, which will allow for certain things later on. But if you see the disc, you stipulate to the disc, okay? You haven't taken the claimant's statement. The claimant's deposition hasn't been taken. Okay, you stipulate to it. A certain amount of time goes by, you've bought it. Okay, it's yours even if you determine at a later date that it's not. Okay? Now, going back to the page before, C, and I'll try to be as brief as I possibly can on this, and then I'd like to get into the example. You can do 3 things with a claim, okay? And you can do 3 things with an injury, a body part, okay? You can pay it, okay, accept it as compensable. You can deny it, okay? Or you can pay and investigate it, okay? And basically what it means to pay and investigate a claim is, you're picking it up, okay? And you have 120 days to decide whether you are going to continue paying or whether you are going to deny it, okay? You have 4 months, okay? Now, when you initiate the pay and investigate procedure, okay, and if you can move back 5 or 6 pages in the outline, you're going to pass the medical questionnaire, and you're going to pass the DWC 25. You're going to see a very short letter that says, "Dear claimant." Okay? This is generally what you need if you are going to elect to use the pay and investigate provision of the statute. Dear claimant, the employer carrier is uncertain of its obligation to provide benefits as a result of the above accident, and again, whether it's an accident or a body part, either. As such, please allow this correspondence to serve as notice of its election to pay and investigate pursuant to 44024. Furthermore, you will be advised of the acceptance or denial of the claim within 120 days of the first provision of benefits. Okay? Now, this is what's important, okay? And I see it all the time, okay? The 120 days does not start when you send a letter, okay? The 120 days starts when you provide the first provision of benefits, okay? So let's say the claimant is sent to a PCP by the school board post-accident, whether the accident's in question, whether the injury's in question, or both, okay? And just for argument's sake, let's assume for a second that the claimant gets injured and is sent to this PCP on January 2nd, okay? You don't send a letter till February 2nd, okay? The 120 days don't start as of February 2nd. They start as of January 2nd, okay? And then what you need to do is you need to diary 120 days from that first provision of benefit. I don't diary 120. I diary 115, 116, 117, okay? Because I don't want to wait until the 120th day, okay? Because God forbid I decide I'm going to deny it, and I deny it on the 121st day, or the 122nd day, okay? Or I'm dealing with a claimant's lawyer that's going to make some kind of creative roundabout argument that, oh, the 120 days starts the date of this, not the date of that, okay? So I want to diary it on the 115th day, 116th day, okay? And I'd even consider diarying it at 90 days, okay? I know that you all handle many, many claims, okay? And a lot of this stuff can fall by the wayside. So if you diary it for 90 days, hey, I got 30 days left, okay? If you haven't done everything that you want to do, you know, oh, here we go, I got 30 days left to do it, okay? But again, it's got to be denied or accepted. Actually, denied. Because if you don't deny it by the 120th day, you bought it. Okay? You bought it. Okay? Now, if you want to page forward, out of the outline, past the 51% equals MCC, we have a leaflet in here, claimant's initial recorded statement. Okay? And this is primarily what's going to apply to you guys as adjusters, okay? You're going to get a notice of injury from the board, okay? And you are going to want to take the claimant's statement quickly. And I know that some claimants, you know, don't want to cooperate. Other claimants do, okay? Nonetheless, we want the recorded statement, okay? As quickly as we can possibly get it, okay? What part of your body did you injure in the work accident? Okay? Is that the only body part that you injured, or were there other body parts? You want to get these claimants to commit, okay? That way other parts don't surface later, and other issues don't surface later, okay? Did you ever injure this body part in the past? Yes, I did. Okay, flag goes up. We've got a potential MCC issue here. What happened? Was it the result of a prior work accident? Was it an auto accident? Was it a slip and fall? You guys know the distinctions. Okay, we went over them with the 3 cases. Okay, work accident, degenerative changes. You know, I started developing back pain, maybe. okay? I had a slip and fall, I had an auto accident, for sure, okay? And you want to get those records quickly, okay? And it may be up to you guys to get those records, because if it's a pro se claimant and there's no counsel involved, okay? Now your 120 days are rolling if you ultimately elect to pay and investigate, okay? Did you ever receive medical treatment for this body part in the past? Okay? Did you receive treatment at a hospital, urgent care clinic, with a family doctor, any other type of provider? And I'm talking about for the prior injury. Okay? Where did you go? Who did you see? What is their contact information? Okay? Were any diagnostic tests done? Okay? What treatment did you receive for the injury? Did you undergo any surgery? Did the injury resolve? Are you still treating for the injury? In your opinion, was the old injury aggravated by the new injury? Why not ask? Is it the same or different pain? Okay? If you guys take thorough claimant statements, okay, you probably won't need us 9 times out of 10. And certainly that makes the client happy. But you got to take a very, very thorough statement. Nail them down. Nail them down. Any other body parts? Okay. Sometimes you're going to get, I don't recall. I don't remember. Are you sure? Are you sure? Turn on the charm. Don't make it adversarial. I like to approach things with sugar before spice. Okay? I'm here to help you, which you really are. But I want to know, are there any prior accidents? I want to know, is there any prior stuff? Because I don't want to be responsible for paying for something that's not mine. Okay? I don't want to pay for something that's not mine. So again, at the bottom, you need to ensure that your questions are specific, that they make the claimant commit to a position on the injury or injuries. If the questioning is thorough, and a prior incidentally, and a prior injury is denied initially and subsequently surfaces, it can also raise a fraud defense. Okay? Or at least give you leverage to settle your case. Okay? Within the context of major contributing cause, we would now utilize the 120-day pay and investigate provision. Okay? You're going to secure the prior medical records. Okay? You're going to forward those to the authorized provider if relevant, to ask what is mine, what is not mine. You're going to forward a letter to and/or conference with the authorized provider. Okay? And you are going to diary the 120th day or prior, as I indicated. Now, just so you know, you need to move quickly. Okay? You need to move quickly. Okay? I've been doing this for almost 20 years. Okay? My firm handles a lot of claims. Okay? I know how you guys feel. You know, it can be difficult when you're juggling multiple claims. And 4 months will go by like this. Will go by like this. Okay? What you avoid controls you. This is a big pain. Your other claims are probably easier to handle. These you just got to tackle as quickly as you can. Okay? Because if you don't tackle them, we could subsequently lose them and be paying for something that's not ours. And it happens. I mean, it happens. It happens all the time. Okay? But use the 120 days in order to address MCC. You know, in my opinion, they go hand in hand. Remember, the 120 days starts at the initial provision of benefits. Okay? Be careful and diary it. Okay? Now, what are the risks in denying versus paying and investigating? Okay? You pay and investigate. Okay? You get the prior records to your doctor. Okay? The doctor says, you know what, more than 50% is pre-existing. Okay? Yay, I can deny treatment. Okay? I've won on this claim. I'm done. Send out my notice of denial, e-file it, send it out, send a letter, everything's great. Okay? But what happens if it is yours? Okay, what happens if it is yours? And now you accept it. Well, in the event that a petition for benefits is filed, okay, you now don't expose yourself to having to pay penalties and interest, which is always a good thing, okay? And if the claimant's attorney has counsel, you don't owe attorney's fees, okay? And with that nightmare case lurking up in Tallahassee, Castellanos, and I know some of you practiced under the hourly provision of the statute, fee-wise, it's a scary proposition. Okay? It's a scary proposition when it comes to fees. Okay? So that's what that allows you to do. Okay? Now the risk is you pay for the treatment, you send them to a PCP, you pay them 2 or 3 months of TP, okay? And then you ultimately deny the case, and we've paid out X number of dollars, okay? But you have your MCC opinion, but so be it. You did what you needed to do. You firmly know that one is not related to the other, and you're done, okay? And you're done. And no one can be upset that we've, crossed our T's and dotted our I's. No one can be upset. Also, we can use the 120-day provision later on in the case, okay? Quick example of the 120-day provision later on in the case, okay? Claimant goes to a PCP. Claimant goes to an orthopedist. Claimant goes to a neurologist. Claimant goes everywhere for this herniated disc, okay? All of a sudden, one of the providers recommends a psychiatric evaluation, okay? Which incidentally, we have to provide. We have to provide. Okay? If an authorized provider makes a referral, we have to provide it. Okay? The claimant goes to this authorized psychiatrist, okay, for initial evaluation. Okay? We forward all the prior records to the psychiatrist. Okay? The psychiatrist says that it's related. Okay? And you guys have heard these terms. Without anything else, I've got it related to the subject accident. Okay? But what we need to do then is we need to either take another statement of claimant, provided the claimant's not represented, okay, or get defense counsel to take the claimant's deposition. And sometimes we may even need to take that deposition without a petition for benefits having been filed, even if we have counsel, and pay the fee. Why? What if we're paying this psychiatrist for something that's not ours? Okay? What if she has or he has a generalized depressive disorder, or an anxiety disorder, or some other sort of psychiatric condition that is long-standing? Okay? You don't know this, I don't know this, the psychiatrist doesn't know this. Okay? We need to look into it. Okay? Once we find that prior history, we need to get the records to the psychiatrist. We need to elect to pay and investigate. We need to find out, is this ours or is it not ours? You send the letter out again. Okay? And you put psychiatric condition on the letter. Okay? And you diary your 120 days. And you find out. Okay? And you find out. If it's not related, then we deny within the 120 days. If it is related, great. We've provided the treatment. We're paying the indemnity benefits, etc. Okay? But the point is, we want to try not to pay for something that is not ours. We want to try to be as thorough as we possibly can, okay, on not only the accident and the claim, but also on the different medical conditions associated with the accident or claim. Okay. Move on to subsequent accidents. Real quick though, remember, you got to investigate quickly. The time will fly by. Time will fly by. Okay. And in the event that it's referred out to defense counsel, because a request to produce has been filed, or because a petition for benefits is filed, discuss it with your defense counsel. Okay? You can lean on your defense counsel to do the investigation. Real quick, and I hadn't covered it, but after the claimant's initial statement, okay, you're going to see a letter in here. And it's to Dr. Juan Perez on the John Doe file. And it's a medical questionnaire. Okay, is everybody there? Okay. Number 3 is your key question. Okay? And you can use this early on. You can use it throughout the life of the case. You can send it to all your authorized providers. What percentage of the claimant's condition is related to the subject accident versus pre-existing issues? Okay? There it is. Send that letter out. Okay? Send that letter out to the doctors. Okay? I have my office call the office managers also. Okay? Because the doctors always don't feel the urgency to complete these, or the doctors will send you a $350 bill and say, I'll complete this for $350. No, please. You should be completing this without charging us anything. just look at your file real quick and let us know. We have an MCC question. Okay? The other thing you're going to see on this letter, and we'll talk about it in the second half of the seminar, is we can also use it to evaluate claims.